Welcome back, everybody. Okay, so again, not too much happening in the courtroom, but so much to talk about in the Tex McIver case. And I want to talk about it right now with my guest via Skype, law and crime trial analyst, and also a host here on the network, Lis Wiehl. Lis, it's great to see you.
Hey, great to be with you.
Now, we were talking right before we came on about the jury questions. Again, the jury's in deliberations. One of the questions they asked yesterday was, if we find that Mr. McIver's not guilty on counts 1 through 4, that's the murder, felony murder, aggravated assault, possession, can we still find him guilty on 5, meaning the influencing a witness charge? What do you think the attorneys are thinking?
You know, I'm looking at it now, the question here on my phone, and I looked at it last night as it came in. And from a prosecutor's standpoint, you know, I don't have any dog in the hunt on this case at all, but when I saw that on my phone last night, putting it away now, if I were the prosecutor on the case, my heart would just fall down. I would just like, that's it. I mean, what's going on here? I mean, if they've gone that far and they're now trying to say, okay, I'm going to throw the prosecutor a bone here.
Well, couldn't it also be, and I've heard so many criticisms say, it's hard to understand what a jury is thinking, and just because they ask a question. So maybe there was a dispute just in the beginning. So guys, let's take it from a basic framework. Where are we at, guys? If we find him guilty this way, if we don't find him guilty this way, maybe they're just trying to understand the law. Maybe not that they.
Yeah, and the fact that let's go on through these questions, right? Can we? So that's question 1, and my heart is, like I said, if I'm the prosecutor now, I put myself in their shoes. I'm like, oh my gosh, I've just lost. Oh, the horrible. But then I go back to question 2, right? Can we get back in the car with the gun? So then I'm like, oh, maybe I haven't lost this case. If they want, why would they want to get back in the car with the gun, right? They're still going through and they're replaying the scene, and so maybe all is not lost. Can we see Exhibit 147, emails on Diane's computer? I'm getting a little bit more thinking, okay, maybe I'm still in the game here. This is, again, if I'm taking a prosecutor's point of view. And I say this, Jesse, because all along we've kind of been saying that the defense has probably done from a lawyer gamesmanship, if you will, a better job. I mean, especially when you looked at the defense. And the way that they closed, for example, their closings were really more eloquent. They weren't over the top. The prosecutors were really kind of over the top, which is unusual. Usually you see the defense, kind of a little bit more arguing, passion and all that. The prosecutors were kind of a little more over the top. So anyway, we've kind of given it to the defense here. I kind of tried to walk it back and said, well, let's take it from the prosecutor's point of view. They've done not a bad job on some things. But, you look at those questions, and they did not look good for the prosecution the other day.
And Lis, we can't forget the final question. Can we see Tex's APD interview video is what they're watching for right now. So, Lis, stand by. Let's listen into the video, and then we'll come back because there's so much to talk about. So let's listen in live. All right, you just heard something interesting that I want to bring up with Lis Wiehl. Lis, we talk about the community here, and when you're listening to this interrogation tape, how well Mr. McIver knew this area where the shooting took place. In fact, he worked nearby. And you can't help but think about the question of the hospital. And it really became a point for the prosecution that this guy knows this neighborhood. He knows if his wife, who just got shot, where the best place to take her would be. You wouldn't take her to Emory Hospital, where they don't specialize in gunshot wounds. Did you think that argument was valid, or did you think that that was a stretch?
I like the point from the prosecutor's point of view. I get what they're trying to argue, that, a rational person would think rationally and would take her, and he's a trained lawyer, obviously, so trained in, we lawyers try to think that we would think rationally and think about taking her to the best place, the trauma care center. I get that, but flip it. The love of your life has just been shot. Worse than that, you were the shooter.
Right.
So imagine all of those feelings. If you really do love this woman, all of those feelings are just rushing through you, and you're not thinking straight, right? You're not thinking like a rational lawyer's thinking, like, this is a problem I need to solve. You're thinking about, oh my God, I just shot the woman I love. And you're not thinking as a rational person. So it kind of actually, I can flip it as lawyers can, and the defense did, and that, I mean, he wasn't thinking that way. He just was, they were just kind of trying to get to wherever they got, and they're lucky they got to a hospital at all. I mean, but then again, they could flip it right back and say, why didn't he just call 911? I mean, really, wouldn't that be the reaction that most of us would have? And a lawyer, not lawyer, wouldn't you, just really have called 911 rather than run around worrying about which way to go and all that? Come on.
Well, Don Samuel, who was delivering the closing argument, was not having any of that hospital argument. And he also said, look, they were only like 7 minutes away from the hospital. What are you going to do? Park, call 911? I have to tell you, though, I think it's this conversation that we're having right here, the conversation we had yesterday, the conversation that we've been having every day and every week of this case is the conversation that the jury is hopefully having, that back and forth. Right. And hopefully they are really, really debating this. And I think that they are. They've asked over 250 questions during the course of this trial. They're asking questions during deliberations. They wanted to see this video again. So let's listen. And that's what I think. I think really that's what it is. They're really, really marinating over this. And
what it all goes to, a couple of things it goes to: reasonable doubt and bringing your common sense to all of it, right?
Yeah.
All of those two things are really, as you said, the great word, marinating in those two. They're bringing their reasonable doubt, and to that, their common sense. And that's how our jury system works. I mean, that's the best.
Yeah, and common sense is important to bring in any kind of case, and particularly this one. So let's listen in a little bit more to Claude Tex McIver's interview with the police days after the shooting. Okay, so again, you're watching live. This is what the jury wanted to see. They wanted to see Claude Tex McIver's interrogation tape again. And we're trying to understand why did they want to request to watch it, and what can we learn from the tape. Again, I'm here with Law and Crime trial analyst and fellow host here on the network, Lis Wiehl. So my first question is, what do you think that they want to gain from watching this tape? What do you think they want to learn?
Okay, well, they want to learn a couple of things. They want to learn how his story may have changed. Remember, the prosecution made a big deal of the fact that he may have told a couple of stories a couple of different times, and so they're looking at this interrogation, and I'm calling it that, to see whether his story has changed from the beginning to the end. And they're also looking very carefully at his demeanor, both here in the interrogation room and also comparing and contrasting that with how he looked there at the scene, how they saw him there at the trial, and really kind of trying to get a differential between the time there and the time at the trial.
So when we look at his demeanor, again, that's a live feed in the courtroom. I think the jury is exiting right now. His demeanor, Tex McIver's demeanor, became a huge thing in this case, huge issue. And the defense has characterized it as saying, show me the playbook where somebody should react to how their spouse dies, let alone when they are the responsible for their death. What do you say to that argument?
That's pretty standard because, the prosecution when the prosecution doesn't have a smoking gun, pardon the pun, but they don't have something, they don't have, the direct evidence. They don't have a witness coming in after Tex McIver has fired the shot. And
well, they have the person who was in the car.
But they don't have somebody standing over him and him looking up and saying, I shot her and I meant to shoot her. They don't have that, right? They don't have a confession. They don't have that direct evidence. So they have to build the case with circumstantial evidence. They have to build the case by trying to look inside his head at the actions after the shooting, because we know he did the shooting, the actions after the shooting, to try to build something inside his head and say, look, jurors, we can look inside his head and show you premeditation, which can be built in a moment, premeditation, actual malice, that he meant to do this, that it was premeditated, whether it was a moment, whether it was 6 weeks in planning, it doesn't matter, that he actually intended to do this. And how do we show that? We show that by his demeanor, the way he acted, the way he talked to Diane's best friend, by the things that he said afterwards. That's the only way they can really show it, because they don't have that confession. They don't have they don't have somebody standing over her body and saying, "Oh yeah, I did it," right? So they have to build it with that circumstance.
You always have to look at the surrounding circumstances. Always, it's important, especially in this case. Now, again, this is a live feed. We should listen in because the attorneys are having a word with the judge. So let's listen in live. Okay, everybody, so that's an interesting tidbit. I want to talk to Lis Wiehl about that. The idea that the jury will have the opportunity to go into the SUV with the gun became an issue earlier on in the case. But another issue is this still considered jury deliberations? Because if you have other people present besides the jury while they're inspecting the evidence, is that really jury deliberations or is it tainted? What do you think?
I think it gets really close to the line when you're having, the other people there, and it's almost as if the jury is sort of, starting to have their own, it's almost as if the jury is starting to have their own retrial, dramatization. It gets very close to start walking some ethical lines here.
Right. Lis, in your experience, aren't jurors most of the time instructed, don't reenact the crime scene, you can look, don't touch? That's why I'm confused here.
Exactly. I mean, you're right to be confused. I think we're confused together. It's nice company to keep, right? I think it's getting very close. I'm not quite sure why the judge is allowing this, especially when now they've been out for quite some time, right? They were out for about 2 hours on Tuesday, and now here we are, into Thursday. So this is quite a lot of time. They've had some good questions. They've had the good questions along, during the trial as well. Now to start going down this tenuous ethical line, if it goes into any kind of guilty verdict for the defense, I think it certainly could be an issue on appeal if there's a guilty verdict for the defense.
Right. That's what we've been talking about constantly throughout this case. There's been criticism of the judge in this case about being too lenient towards the prosecution. That has been a criticism. Whether that's actually true or not is a different question. But we have talked about the fact that if Mr. McIver is found guilty on any of those charges, there may be grounds in terms of an appeal, but that's for a later issue. I want to talk about what's happening right now, right here. The jury is deliberating. Some people are saying maybe they'll come back tomorrow, maybe next week. How long can a jury deliberate before we enter into the territory, and I'm crossing my fingers here, I don't even want to say it, a mistrial, a hung jury? How long can they actually deliberate before they ultimately get to that impasse?
Well, you know as well as I do that it can go on for a long time. I mean, there's no set, there's no line in the sand where they say, okay, that's it, your time's up, you can't go any longer. But the jury can come back to the judge and say, look, we've reached an absolute impasse. We can't go any further. And then the judge will turn back to the jury and say, really, can you go back and work harder? If you take some more time? And depending, every state is a little bit different. And this is a state law case as opposed to a federal law case. So every state law is different. But they can go back and say, look, you take some more time. And the judge can scoot them on back, and the judge can say, look, you've got to go back, and force them to go back. And then the jury can come back and say, look, well, we've done it again, and come back, and we just can't. And it depends on how hard the judge pushes to have them go back a number of times before the jury comes back and says, we just can't, absolute impasse. And then what the judge will do, in most cases, in most states, is the judge will poll each of the jurors to ask them, is this your absolute decision that you cannot decide? And each juror will say, that's right, we can't decide.
Well, I should say, and I haven't mentioned this earlier, is we do have a poll up on Twitter on our page where you can go and vote to determine whether or not you believe the jury will come back with a verdict of guilty for murder, not guilty of involuntary manslaughter, or not guilty across the board. And last time we checked, it was pretty split. So maybe that split that we see amongst the viewers could be the split that we see amongst the jury, and hopefully not. I think we all want a verdict and a conclusion to this case. Now, Lis, stand by. What I want to do right now, as we have some time, I want to replay for you the testimony of Danny Jo Carter. Danny Jo Carter, as for anybody who knows this case, was the driver. She was the driver in the car. I should even say the driver in the crime scene. So she was driving. Diane McIver was in the front passenger seat. Tex McIver was in the back. Tex shot Diane. She was the person there. Her testimony is so crucial. And she was brought out by the state. And really, she was on for a long time. And the jurors definitely listened to every word she had to say. So I want to play some of her testimony for you right now. We're in Verdict Watch, ladies and gentlemen, in the Tex McIver case. And so what we're doing is we're recapping everything about this case. We don't want you to miss anything. We're keeping a very careful eye on the courtroom. We believe the jury later on today will have an opportunity to inspect the SUV with the gun. They might go into the back seat and try to understand what happened. And really, that's what we're all trying to understand, what happened in the night in question. I want to bring in again Law&Crime trial analyst and fellow host here on the network, Lis Wiehl. Here's the question as we watch Danny Joe Carter, and that's who was just on, Danny Joe Carter, the person who was driving the car, the main witness, the star witness in this case. So the debate here is the defense could say, and which they have said, if you're going to kill your wife, would you really do it while Danny Joe Carter, Diane McIver's best friend, someone who wouldn't even be loyal to you, would be driving the car, let alone just a witness, versus Tex McIver being in the back seat and saying, you know what? At that very moment, I might not have planned to kill her, but I wanted to kill her right at that moment. And who cares? Everyone could say financial motive, whatever. I wanted to kill her right then, and I shot her. That was not part of some deep plan. I had enough. I shot her right there. Those two arguments right there between that diabolical plan to kill her in this way versus the other way. I mean, how do we understand that debate?
And or was it just the perfect motive, perfect crime because it was so poorly planned? You know, and flip it on the other side. Is it just that, you know, it was just such a, the defense argues that nobody would plan a murder like this. It's just such a, such a dopey plan to make, you said, with her best friend right there, and the way that it was, who would do that? And the way that it was done with you using her, you know, you ask the victim, this is what the defense said in the closing, honey, you know, can you hand me the gun that I'm going to kill you with? I mean, who asked the victim to hand them the gun? Nobody does that. Or is that just the perfect crime to commit because it looks like the dopiest crime to commit? Right. You know, if you turn it around, right?
Right. So what's so interesting about this case, and I think one of the reasons so many people are following it, is you can take a fact here and flip it either side. So I really want, you just mentioned it, Diane McIver handed Tex the gun, right? She was shot. When she was brought to the ER, she said to the doctors it was an accident, right? So if you're the defense, so much to play with right there. If she thought it was a threat, she wouldn't have given him the gun. They had a great relationship. She said it was an accident. But couldn't you flip it and say, wait a second, she had no idea Tex was going to kill her?
No, and you know, maybe she knows in her heart that she's dying, and she doesn't want to believe. I mean, would you? That this man that you're married to wants to kill you? That's the last, you don't want to believe. You're in denial. That's a very common thing. You're in denial. And let me just follow up with that. She said when she gets there, it was an accident, but later, after she's been there for a while and she's being wheeled to the place where they're going to try to resuscitate, you know, keep her alive, and ultimately they don't, obviously, they ask her, do you want to see him? And she says no.
What did you make of that? What did you make of that?
Then you can argue that. She's had time to think. I could make of that, and the jurors could be making of that. Okay, she got there. Her first instinct was, okay, it was an accident. He didn't mean to kill me. But then as she has time to kind of think and she's realizing she's going to die, and she replays some things in her head that she's thought of over the last week or months or whatever, you know what? This wasn't an accident.
But couldn't you say she knew that Tex shot her? There was no doubt about that. Whether it was an accident or murder was a different question. So if he shot her, she was upset at him no matter what it was.
Right, but in those moments at the hospital that she has there, as she is going to die, right? She's replaying. This is what could be happening. She's replaying in her head things that she's remembering over the last weeks, months, whatever, about the will, about Austin, the guy that the young man they befriended, that they both befriended as almost a godson, that they want to leave money to, all of that, and she becomes to realize it was no accident. He wanted to kill me. And that's why she says, no, I don't want to see him.
Well, it's rare that you get the final words of a victim. And that becomes a crucial part of the case. I mean, we covered the Jessica Chambers case, which was a really sad case about this young girl that was burned alive, and everybody was trying to understand what her last words were and who she was saying did this to her. So when you listen to the final words of Diane McIver, it really plays both ways. She said it was an accident, great for the defense, But then, like you said, that other statement about not wanting to see Tex plays for the prosecution. And we listened to so much of the testimony in this case, and we listened to Danny Jo Carter. Do you think that the prosecution did a strong job of articulating the relationship between Diane McIver in terms of a financial dependency? Do you think that they really articulated that well, that Tex McIver was dependent on his wife, and without her, he could have all of this influx of cash. He's now a independent man. He doesn't have to make payments to her. Do you think they articulated that well?
They had some really bad facts against them, which came out in the defense, and one that remains really strong in my mind, came out very strongly for the defense, is Tex McIver, soon after Diane died, cashed out in some stocks that he had, in a company that he had, for about, I may get the amount just a little off because I don't have the notes right in front of me, but it was about $740,000 that he had in stocks or something in this company.
You're talking about in the mining company, the
yes,
interest that he had in the mining company, right? Yeah.
$740,000. Now, I don't know. I mean, I don't care how rich you are. $740,000? That's a lot of money. You can't have been that poor. And yeah, okay, he didn't have the law practice anymore, but he you know, they put on, frankly, a very, very boring, I mean, I'm sure he's a very nice guy, head of the law firm, the prosecution did, who went on for long time. I think they could have wrapped that guy up a lot faster. They could have just said, here's what he was making, here's what he ended up making, and he was no longer an equity partner. They just needed to wrap that up a lot faster. I mean, it's just so scintillating for us lawyers. Not. You know, so how did it play for the jury? I mean, come on. You needed to have that guy on there in about 30 minutes. Could have done it. It dragged on way too long. They needed to get that message out and quick, because once they put motive into the case, which they didn't have to do legally, but we all know they had to do to convince the jury, they needed to get it on there and fast and be anticipating what the defense was going to do with that $740,000 right up front. That's a lot of money, Jesse.
It's a lot of money. It's a lot of money, and money became such a big issue in this case, especially since, and I keep saying it, Diane McIver and Tex McIver came together at a later point in life. They didn't grow up as high school sweethearts and made their wealth together. She was a highly successful and accomplished business executive. He was a very strong lawyer and was also prominent in the community. He's a prominent lawyer. Everybody knew about him. So when you have these two people coming together, you have to imagine money became an issue. Lis, stand by. What I want to keep doing is playing some more of Danny Jo Carter's testimony, because, again, there were so many important witnesses in this case, but rarely do you have a witness that was at the crime scene, at the shooting, driving the car. You don't always have this. So I want to play some more of her testimony from earlier in the case. You're watching the testimony of Danny Jo Carter. She provided her really incredible testimony earlier on in this case, and she was the eyewitness to this whole shooting. She was the driver of the car. And you see how the prosecution created that little demonstration there for the jury. Important for them to see that. It gives them a visual of what happened. Now, we are in jury watch. We are in verdict watch, excuse me. We're waiting for the jury to come back with a verdict. I'm keeping a very careful eye on the courtroom. As soon as there's an update, we'll make sure to go to it. I want to bring back Lis Wiehl. Lis, what did you think of Danny Jo Carter as a witness? I found her to be very credible. I felt she didn't always give the answers that either the defense or the prosecution wanted, and I think that's what made her a credible witness.
Absolutely. And don't forget, she was the best friend of the victim, but also a friend of the defendant as well. I mean, I don't think she had anything out for him. In fact, I think, you know, way back, I mean, these people have a long history together. She actually had dated the defendant. I mean, this was way back before she'd even met the victim. So there was a long history there. But you know,
was it Danny Jo or was it Janie Calhoun? I sometimes get confused.
I thought it was Danny Jo.
I might have to check that. I'm not sure. I think it might have been Janie Calhoun. Listen, to tell you the truth, this is a conversation that kept being brought up by the prosecution about Tex McIver's love life.
Insinuated, exactly. Anyway, so there was a lot of that, but they definitely knew each other for many years, and they were all friends. So it wasn't like she was out to get, you know, Tex. She wasn't out to get him at all. seeing that, even the replay, because we've seen it now several times, of her in the seat there, the driver's seat, it's kind of strange, right? Every time you see it, I mean, it's still just having her there. It has a real impact of seeing her there and going through what she must have gone through. I find her to be extremely credible. I mean, again, she's not on a side. She's not picking a side. Yes, she's called by the prosecution, but she doesn't come across as though she's picked a side.
Yeah, it's one to watch, and we're going to keep a careful eye on this, as well as the fact maybe that testimony really resonated with some of the jury in their deliberations. So again, we will be carefully watching the Tex McIver case. But now I want to switch over. I want to go down to Florida. I want to go to the Brian Hyde case. We have a live feed in there. Another witness is on the stand. Again, this is a quadruple homicide. 3 people, including one who was pregnant, were brutally murdered, and this, unfortunately, it's so sad to say, there was an unborn child that was taken as a result of this horrific, horrific attack. So let's go in live into the courtroom.
You would agree that Mr. Kelly was not supposed to be at the house?
Yes, sir.
And would you agree that Mrs. Dorla Pitts, had a overnight schedule?
Yes, sir.
That she would work? Okay. So you were not in town that week, or you had left the day before?
Yeah.
Okay. So as far as who would have placed Mr. Mr. Michael Kelly's car, you have no knowledge?
No, sir.
It would be fair to say you have no knowledge when it was placed there?
No, sir.
Thank you, sir.
And Mr. Pitts, the understanding that you had with your wife, Ms. Dorla Pitts, was that Michael Kelly was now not at your residence. Is that correct?
This is a mutual agreement.
Thank you. No further questions, Judge.
You may step down. Thank you.
All right, so that was Dorian Pitts. That's the victim's husband. Really, really sad case out of Florida. Again, Brian Hyde is on trial for viciously stabbing and killing 19-year-old Michael Kelly, his girlfriend, 17-year-old Starlet Pitts, and Starlet's mother, Dorla Pitts. Now, again, the person you just saw, Dorian Pitts, was the husband of Dorla Pitts. It's really, really sad case. Lis, when you see a case like this that's so brutal, how do you find a jury that will not be persuaded one way or another based upon the horrific, horrific nature of what happened to these individuals?
It's really hard, and the judge here becomes absolutely crucial, because the judge has to walk the line of the evidence that is allowed into the trial, because prosecution should actually, if they're really good, should be careful, because they really should not allow too much of the gory stuff, just enough to actually show what happened, and there were the victims, obviously, and to show the scene as much as they need to, but not so much as to create reversible error to the point where the jury is going to vote with their emotions as opposed to voting with on facts, and that's so hard, Jesse, as you know. Sure. In a case like this, to have a jury not be swayed by their emotions, because lawyers want to prey a little bit on emotions, but they can't, as from a prosecutorial view, do it so much that it's clear error and they're going to get reversed anyway.
Yeah, you're 100% right. Not an easy case to be on a jury, and not an easy case to follow. But again, we do have a live feed in that courtroom. A new witness has just taken the stand. I'm hoping we have our feedback. I'd like to listen in. Again, this is the Brian Hyde case out of Florida. A lot at stake here, so let's listen in. You're watching a live feed right there in the Brian Hyde case out of Florida, a quadruple homicide case. Really, really, really horrible details of it about 3 individuals who were stabbed, including one who was pregnant, and that unborn child died as a result of this attack. Again, I want to bring in Lis Wiehl real quick before they go into the next witness. Lis, the defense has gone with the tactic of saying that the police have not done a thorough enough investigation, that they should have inspected different areas and they didn't, that there was hair found at the residence that they didn't test, that there was multiple weapons that could have been used. I mean, the medical examiner said that it might have been possible that multiple weapons were used. How effective, in your experience, is going that tactic and saying to the jury, you know what, jury, the police in this case only focused on my client and they didn't do a thorough enough investigation? Does that work?
It's a fair tactic, meaning fair meaning Midland. If you don't have great facts, if you don't have anything else, you go for that. It's sort of like, you know, they were looking at, well, you could have had you could have gone for arm hair, you know, hairs off your arm. You didn't go for that. And the witness on the stand had to say, no, yeah, I guess I could have tested for hairs on the arm, and we didn't do that. All the things you could have done in the universe and that we didn't do. And that is a very, very usual tactic. Again, if you really don't have a whole lot of other things to go for, it's not a bad tactic, because a juror can sit, and again, I'm saying a juror, and I said that on purpose, a juror could be sitting back there in deliberation when it gets to that saying, you know, with all the highfalutin things out there they could have done, they didn't do this, and that leaves me with reasonable doubt, and that's what you need. You just need one of those jurors to say, hey, they didn't do that. That leaves me with that reasonable doubt. I'm not going to say guilty.
Yeah, I mean, the defense focused on the fact that foreign hairs, that were found on the victims, they were never tested. So it's interesting when you get to this point, you get to a trial, and not everything was tested and not every avenue was explored. I mean, it's really, we've seen this in other cases where the jury does not like that, and many times it could lead to a not guilty verdict or at least a mistrial.
Juries do not like, nor should they. We don't like when anything is looked at and it could be sloppy, and especially when you're talking about a case as important as this where lives were lost, you know, so especially as we talked a few minutes ago, so brutally, then we're at an acute, heightened, I just made a new word there.
I like it. I'm going to go with it.
Okay, there we go. Sense of just justice here, and that everything should just be at the most high level of really looking at things and crossing those T's and dotting those I's to that acute sense of really doing it right and not being sloppy, for goodness sakes.
Then again, the flip side of it is Mr. Hyde was found by police driving one of the victim's cars erratically, and also Mr. Pitts, who you just heard on the stand, he has talked about previously the fact that when he called his wife, Dorla Pitts, the last thing you heard her said was, "Brian, what happened? What happened?" Again, that is pretty strong evidence to say that there's a reason Brian Hyde is on trial right now, and you have 4 people that were killed, and you need an answer for that.
Of course, but I mean, again, if I'm the defense, I say, yeah, okay, all that's great, but does that really take the the forensic investigators off the hook? If I'm the defense, I say, absolutely not. If you're the forensic investigator, why didn't you do this? Why didn't you do that? Now, the real answer, okay, in the real world could just be, hey, you know, they're not going to say this, but hey, we thought we had enough. We didn't need to do all these other expensive tests. We had this guy dead to rights. He did it. We had enough. We didn't need to do it. But if you're the defense, you grab onto that. You know that that's what they were thinking. They can never say that on the stand, right? They can never say that on the stand. So you poke a hole in that, you drive that truck through that hole, and you say, that's going to be my case because that's going to create reasonable doubt. As I've got all these things that they didn't do because they thought they had enough, and I'm going to try to create reasonable doubt with that.
Well, like with everything, we'll have to see. Now, again, Lis Wiehl, thank you so much for joining us and analyzing both this case as well as the Tex McIver case. It was great to have you on to talk about both.
Got it. Thank you so much, Jesse.
All right, and I will be signing off as well. Aaron Keller will be signing in as your afternoon host. We'll be covering both the Hyde and the McIver cases here on Law and Crime. Let's go back live into the Hyde case.